Good afternoon and hello. My name is Nadine Chabrier. I'm Senior Litigation and Policy Counsel at the Center for Responsible Lending. We're holding this briefing today because the Supreme Court will hear oral arguments in CFPB versus CFSA on October 3rd, 2023. The Consumer Financial Protection Bureau is asking the court to declare its funding structure constitutional and overturn the Fifth Circuit Court of Appeals opinion. Why? Because this Fifth Circuit's opinion has no basis in the Constitution's text, case law, or history, as the Second Circuit concluded, and as our experts will discuss. This case represents an unprecedented interpretation of the Appropriations Clause that could upend not only financial regulators, but many government agencies and programs. The decision could not only invalidate an important protection against predatory lending, but could also undermine the CFPB's ability to enforce the law. Through its enforcement powers, CFPB has won $17.5 billion in restitution or canceled debts for 200 million people. These actions assisted homeowners who were defrauded by their lenders, depositors forced to pay illegal overdraft fees, borrowers facing racial discrimination, and people with inaccurate information on their credit reports.
Hi, I'm Brianne Gorod. I'm Chief Counsel at the Constitutional Accountability Center. And I'm going to kick things off by talking about the Constitution, specifically the text and history of the Constitution's Appropriations Clause. Because for any judge or justice who professes to follow the text and history of the Constitution, this should be an incredibly easy case. Indeed, as the Second Circuit Court of Appeals noted in an opinion written by a judge appointed by President Trump, it could find, quote, no support, unquote, for the Fifth Circuit's decision in the text and history of the Constitution. So what does the Appropriations Clause say? Quote, no money shall be drawn from the Treasury, but in consequence of appropriations made by law, unquote. That's it. That's the text of the Appropriations Clause. And as a threshold matter, the CFPB's funding structure cannot violate this clause because its funding is not drawn from the Treasury. It's paid from the earnings of the Federal Reserve System. To affirm the Fifth Circuit's decision, the Supreme Court would have to hold that the clause's reference to the Treasury means something other than what it says. And the court would have to explain what exactly that is. But the court doesn't even need to address that question because the text of the clause is satisfied here regardless. At the founding, as today, to appropriate money by law simply meant to designate a purpose for that money in a law that's passed through the normal process for enacting legislation. Because the statute authorizing the CFPB's funding does exactly that, it is an appropriation made by law. The Appropriations Clause contains no other restrictions, no other procedural requirements. The Fifth Circuit's contrary decision is based on several new rules of that court's own invention, rules that have no grounding in the text of the Constitution. According to the Fifth Circuit, appropriations legislation must be temporary. According to the Fifth Circuit, it cannot be combined with the enabling legislation authorizing the activities in question. But those are the Fifth Circuit's rules, not the Constitution's. Because again, nothing in the Constitution's text imposes those limits. And it's not as if it didn't occur to the founders that there might be some contexts in which there should be limits on Congress's discretion over appropriations. It did. And where the framers wanted to impose limits, they did so explicitly. Notably, they gave Congress the power to raise and support armies, but provided that no appropriation of money to that use shall be for a longer term than 2 years. That was a limit explicit in the text. The Appropriations Clause contains none of the limits or requirements that the Fifth Circuit imposed. So that's the text. Let's talk for a moment about the history. Why did the founders give Congress this discretion over appropriations? The appropriations power developed in England and later in America as a legislative check on executive power, not a judicial check on legislative power. None of the historical precursors to the Appropriations Clause in England or the American colonies or the early American states included any of the limits on legislative discretion that the Fifth Circuit has attempted to impose on Congress. And this history underscores the extent to which the Fifth Circuit's decision turns the Appropriations Clause on its head, allowing presidentially appointed judges to overrule the will of the people's elected legislators on funding matters runs directly contrary to the clause's purpose and its history. The founders agreed, as James Madison put it, that the purse strings should be in the hands of the representatives of the people. And throughout our nation's history, that's exactly where they've been. Congress makes the judgment regarding how different federal agencies should be funded. Notably, Congress has never relied exclusively on annual appropriations or time-limited funding. Instead, it has given federal agencies perpetual, dedicated funding sources like the CFPBs since the nation's founding. Indeed, the very first agency it created in July 1789, the Customs Service, wielded authority over a vital component of the economy and was financed not with annual appropriations, but with an indefinite revenue stream provided in the legislation creating it. Congress employed that model for other agencies throughout the nation's first decade. And this is incredibly important because the Supreme Court has recognized that the nation's earliest laws provide weighty evidence of the Constitution's meaning. In sum, the Appropriations Clause does not restrain Congress, but rather empowers Congress to restrain the other branches by preventing unauthorized spending from the Treasury. It doesn't empower the judiciary to control Congress by second-guessing its funding decisions. When Congress decides that an agency should have dedicated funding or indefinite appropriations, it's not ceding its power to the purse as the Fifth Circuit claimed, it's exercising that power. And if the court were to conclude otherwise, it would not only be taking a position at odds with the text and history of the Constitution, it would be aggrandizing its own power to the detriment of Congress. That's why, as I said at the outset, this case should be an easy one for the court. I'll leave it at that for now, as I know others will be talking about the significant consequences if the court doesn't adhere to the text and history of the Constitution and respect Congress's authority to make funding decisions. But I'm, of course, happy to answer any questions at the end of the call. Thank you very much.
My name is Aziz Huq. I'm a professor of law at the University of Chicago, and I worked with Brianne on the amicus brief concerning the original history or the originalist context of the appropriation. Reveals several instances in which Congress, immediately after the creation of the nation, employed funding structures that are parallel to the one used for the CFPB. In other contexts, the Roberts Court has looked to that early history as evidence of the meaning of the Constitution. So here we have a case in which almost every indicator of constitutional meaning is pointing in the direction. Look at the rule that it proposed, and to think about what the effect of that rule would be. What the Fifth Circuit said is that the appropriations for the CFPB were unconstitutional because they were, and I quote, perpetual, self-directed, and double insulated. The Fifth Circuit said that its ruling would not have implications for any other agency of the federal government because no other agency had those. Is unpersuasive, deeply unpersuasive, and unpersuasive on its face. There are a multiplicity of important federal agencies, particularly in the financial domain, including the FDIC, which ensures your and my ordinary checking and savings accounts, the Officer of the Controller of the Currency, the National Credit Union Administrator, and the Federal Housing Finance Agency, which is responsible for much of the US mortgage market, all of which have funding streams that are uncapped and are funding structures. And CFPBs is the idea that the CFPB structure is double insulated. What did the Fifth Circuit mean by this? What it meant by this was that Congress had allocated the Federal Reserve Authority to generate funds, and then from the Federal Reserve's funds, the CFPB would draw funds. The problem is that if you think that Congress has to exercise direct control over appropriations, it's hard to see why a single instance, the unconstitutionality of all of the agencies that I just described, and also of the Federal Reserve, the main Federal Reserve itself. So the Fifth Circuit's ruling, were it to be affirmed by the Supreme Court, particularly in the context of a looming government shutdown, would first create an immense amount of uncertainty about the basic architecture of our financial system, and second, create, potentially worse, a vacuum at the core of that financial system that would have debilitating consequences for the national economy and for the US's global position. This is why in a Politico piece immediately after, some of the bank lobby have made amicus brief to the court. This is the idea that the court could rule in favor of the challenges to the CFPB and then stay the remedy for a year. And it's certainly true that the court has done this once before in a case that concerned the bankruptcy system. In that case, however, Congress was unable within a year to come up with an alternative arrangement. It missed the deadline the court imposed, and it was several years before waivers to the CFPB in terms of uncertainty and in terms of a loss of confidence in financial architecture in the United States would impose irreparable and potentially massive harms to the US economy.
Thank you, Aziz. My name is Elise Hicks, one of your co-hosts. I am Consumer Policy Counsel at AFR. And if you all wouldn't mind putting your questions in the Q&A section in the chat, and we will address questions once all the speakers have gone. Our next speaker is Emmaus Garrity. He's a former acting assistant Treasury Secretary and will be discussing the history of Dodd-Frank, which created the CFPB and endowed it with this authority.
Thanks you, Elise. So my name is Emmaus Garrity. I served in the Obama administration from the very first day of the Obama administration until the very last day. So, and on the fourth day, I was asked by the Treasury Secretary to start writing down what we would do after the financial crisis. Geithner had a belief, which was correct, that we should probably reform things after that. And so we literally started, he said, read everything, start with a blank sheet of paper and write down the principles, and then we'll go from there. And I had the privilege of working with an immense team over 18 months to get that process started. But because of my vantage point, I was privy to basically every material process part of that. So what I want to do is just talk about three dynamics here in the history of Dodd-Frank, which show clearly that the supposed constitutional concerns are really figments of a conservative judicial movement that seeks to undermine the administrative state in general, rather than long historical concerns around the constitutional funding provisions. And I'll answer this as a non-lawyer with procedure and with history and with stories rather than with legal analysis as others have done. So the three things I want to talk about is, first of all, that the administration was well aware of the possibility of constitutional challenges in general and was explicitly not concerned about constitutional challenges on the CFPB's funding. That's the first point. Secondly, that the funding structure and the governance structure for the CFPB originated solely within Congress, and so was a creature and a function of congressional deliberation. And then thirdly, that the financing structure, and going to Aziz's points about double insulation, the double insulation is not a true statement about the CFPB's functioning. It was not a true statement at the time the law was passed. It is not a true statement today. So let me go through these quickly in turn. So one thing that I think people generally understand, but it's worth reminding, is that any time the administration proposes legislation, it generally goes through a interagency review process. And in the history of Dodd-Frank, Congressman Frank and Senator Dodd asked the administration to deliver to them a full draft of legislative text, which we did. And in that process, that meant that we actually sent, the Treasury Department sent a full 1,000-page draft of legislation through an interagency review process. And the DOJ naturally was very concerned with the, their participation and their role. At one point, DOJ actually wanted to be on the Financial Stability Oversight Council. So the DOJ was sensitive to their constraints, and they were particularly attuned to the CFPB. And the reason they were attuned to the CFPB is that the CFPB is in law and was originally proposed to be authorized to sue and to bring enforcement actions in court under its own authority and without needing to defer to the DOJ to pursue itself, defend itself in court or to bring enforcement actions in court. And this is an authority that the DOJ traditionally has guarded jealously. This issue was raised all the way up to Attorney General Holder at the time. It was negotiated directly between Geithner, Holder, and the president. And in that context, there was no objection to the CFPB on OLC or constitutional grounds. And I think that this is important because you can imagine that in the context of an interagency dispute about agency authority, if there were a constitutional challenge to the CFPB, that would be quite important to the DOJ. And in that context, therefore, if the OLC staff or others who were concerned about the CFPB's authority, they certainly would have raised that concern. And I can tell you, having been in those conversations, there were no concerns with the CFPB's funding structure in the original proposal or the possibility of the CFPB being an independent agency. These were not constitutional concerns in the interagency process. The second thing to note is that the CFPB's governance structure went through a number of iterations in the legislative process, all of which originated in the House and the Senate because we originally proposed a bipartisan or a nonpartisan board. And then in the House, that proposal shifted to a 5-member bipartisan commission. And then in the Senate, this shifted again to the structure that finally passed, which was a director with funding through the same mechanism that the Federal Reserve is funded by. And it's important to note that this is a creature of Congress and congressional deliberation, and therefore an expression, as Brianna and Aziz said, of congressional authority rather than an overreach of executive authority in the creation of the CFPB. So not just on the technical grounds, but on the substantive grounds that this was Congress's choice for how to fund the agency. And I think it's worth noting a small point, but an important one in the political history of the funding decisions is that at this time, the political debate was very motivated by the idea from many Republicans that we needed to keep government small, that new government agencies would be adding to the bureaucracy. And therefore, Senator Corker from Tennessee, who at the time was really the most important Republican on the banking committee who was considering supporting Dodd-Frank, although ultimately he voted against it. It was very important to Corker in his attempts to find a version of the bill that could be acceptable to him, that he could say to his constituents that they did not create a new agency. And that's where the original sleight of hand for calling the CFPB a bureau rather than an agency originator. It was in a dialogue with Senator Corker. And so the financing structure does, on its face, look to be a financing structure under the Federal Reserve. But if you look carefully at the legislative text and at the legislative history, you will realize that there is no change to the Federal Reserve's authority. There is no change to the Federal Reserve Act in the creation of the CFPB. So the CFPB is funded with the same mechanism that the Federal Reserve is funded with, but it is not funded by the Federal Reserve System. And I think this is an important history because it underlies that there was a conservative talking point about double insulation that has no legal reality. That in fact there is a fiction that the CFPB is governed by the Federal Reserve Board, and that fiction has no legal or legislative historical reality. And then I think the last piece, which others have stated, but I do want to underscore, is that as Aziz and Brian pointed out, there's an argument by the Fifth Circuit that the funding is perpetual and self-directed. But unlike many other agencies, and so for example, or programs inside the federal government, for example, when I was at the Treasury, there's a little known but hugely important program called the Terrorism Risk Insurance Program. The Terrorism Risk Insurance Program says that if in the event of a terrorist attack, the government itself will reinsure real estate losses above $100 million. That's a hugely important program, and it is funded as a permanent, indefinite appropriation. Congress has no idea how much that will cost or when a terrorist attack will come. But nonetheless, there is an agency, there is an entity within the Treasury. It has dedicated staff. It has a small amount of funding, and Congress does not set that funding in any way, nor does Congress make any judgments about that funding in the event of a terrorist attack. This authority has never been used, but it just points out the many, many ways in which permanent funding streams can be created. And unlike something like the Terrorism Risk Insurance Program, the CFPB's funding is explicitly capped. And not only is it explicitly capped, but it's explicitly capped in a manner that underscores congressional authority. So the way that the CFPB's funding is structured is it is set as a percentage of the total revenue that passes through the Federal Reserve Board. And there's an explicit statement that the appropriation, that if the CFPB's needs go beyond that cap, they must come back to Congress and have those needs met through new appropriations. So as we look at this history, we see very clearly that there were not constitutional concerns at the time, that the manner of funding was as an expression of congressional authority, and that the mechanism is simultaneously is purely ministerial, as others have pointed out. The CFPB is not governed by the Federal Reserve Board, and as Congress created this mechanism for funding, they explicitly maintained their authority to govern the funding above a permanent minimum. And with that, I'll hand it over.
Hi, everybody. I'm JP Schnapper-Casters. I work at a boutique law firm and do a good number of amicus briefs, and I co-authored the brief in this case on behalf of military and veterans groups. Our signatories included 16 national nonprofit organizations in the military and veteran space, including the Military Officers Association of America, Iraq and Afghanistan Veterans of America, and 2 individual experts on the military community, Hollister Petraeus and Colonel Cantwell, who formerly headed the CFPB Office of Service Member Affairs. These are nonprofits that provide services for tens of millions of service members across the country, veterans and their families. These are also, frankly, groups that don't often weigh in on Supreme Court cases, but they had a strong interest in this case. And the core thesis of the argument they put forward to the court is consumer protection matters to the military community, full stop. And I'll just highlight 4 key reasons why. The first is financial readiness. This is a formal military doctrine that exists at the Pentagon and a number of the service branches. When we think of readiness, we often think of physical training, weapons training, getting ready to deploy overseas in all the sort of physical sense. But the Department of Defense also formally prioritizes and promotes in a number of ways a concept called financial readiness. The idea that to be operationally ready to go out in the battlefield, service members and their families need to be financially stable. And I mean, basically, you don't want to worry if you're going to Afghanistan. You don't want to have to be distracted and worried. Oh, is my spouse back home getting targeted with a fraudulent financial products? Are we going to be able to pay the bills? Did we miss the credit card payment last month? So this is for good reason. This is a doctrine that has predated the creation of the CFPB and Congress and is formally adopted by all branches of the military, the chairman of the Joint Chiefs of Staff, the combatant commands. There are lots of military documents and programs that talk about financial readiness. Congress, for its part, of course, has also enacted a number of laws that help improve financial readiness and consumer protection for people in the military and their families. And so there is this sort of enduring connection between consumer protection and operational readiness. The second reason why consumer protection and the CFPB in particular matters for the military community today is because of the real world problems that the CFPB helps combat and that matter to the military. So for example, predatory loan practices were a major concern of Congress. They've been a major concern of the CFPB. And they crop up all over the country and repeatedly target members of the military and their families. And there are practical reasons for that. We talk about a few of them in the brief. People who are new to the military, young enlisted members, may not have a lot of financial experience. They are often physically concentrated around one base, which makes them easier to target. They probably don't have a car, and so there are all sorts of cases around predatory auto loans around bases, people charging crazy interest rates to 20-year-olds who, for the first time, have a steady paycheck, and predatory lenders know they have a steady paycheck, they have a steady job because they signed a contract with Uncle Sam to stay in the military for the next 8 years, and folks have used that. And you don't have to take my word for it in terms of the practical problems that the CFPB addresses here. The amici that I represent hear from their members, tens of thousands of members, in surveys and public forums about how these problems arise and how deeply distracting they can be. And we give some more examples about that. For example, just as of July of 2022, last summer, there were 286,000 complaints by service members, veterans, and their families to the CFPB. So this is a real hub for listening to service members and responding to the practical concerns that they face every day. The third reason that the CFPB matters to the military community is just its actual enforcement record. And we go through a number of examples, cases, settlements, many millions of dollars recovered, injunctive relief, restitution. I won't bore you with all the citations and sums today, but think of online lenders that target young enlisted members, overcharging for insurance products, deceptive rep. There was one case where a bank was calling members of the military and saying, you had an overdraft fee, or you're in debt, and not only do you owe us, but we're going to call your military commander if you don't pay us back in a certain way. Really bad, which is not true, and also illegal. So just really bad stuff that obviously harms and distracts service members and their families. And there's voluminous evidence of all the different statutes that the CFPB enforces to the benefit of service members. The prime one is the Military Lending Act, but as we go through the recent years' actions in more detail, it's also under the Electronic Fund Transfer Act, the Truth in Lending Act, Fair Credit Reporting Act, etc. So the sort of robustness of this docket that the CFPB has developed in service of service members, I think, underscores why it's so significant to have a lead federal agency on these issues that has substantive expertise to protect the military community. One other little footnote is the CFPB also has a civil penalty fund, which allows them to compensate harmed service members when an individual defendant has gone bankrupt. So there are all sorts of really important tools that the CFPB can and does use to help people in the real world. The fourth point is what would happen under the Fifth Circuit ruling. Bottom line, gutting the CFPB would be deeply problematic for the military community, for active duty reservists, veterans, and their families. It would halt the enforcement of a number of important laws and regulations that specifically protect service members. It would undermine service members' financial readiness at the end of the day, and that has consequences for mission readiness and for national defense. It also, I will say, has consequences for security clearances, because one of the number one reasons for losing a security clearance for folks in the military is due to financial problems. And so we can see the sort of deep interconnections here between financial readiness and operational readiness. The last thing I'll say that my clients made a somewhat more technical point, but important nonetheless, which is about the funding mechanism for the Department of Veterans Affairs, which, as you can imagine, administers billions of dollars in federal benefits for veterans and their health care. The VA relies on a tapestry of different funding mechanisms like other federal agencies. Mandatory funding, discretionary funding, advanced funding, multi-year funding, as well as some funds derived from non-treasury sources, just like this case. And so the Fifth Circuit's reasoning here seems to call into question some of those means of congressional funding, and the implication being that perhaps certain aspects of how the VA is funded and run would also be imperiled by the logic here. That obviously would endanger Congress's flexibility in continuing to fund and operate the VA. In the short term, I think it could create budgetary problems and some operational uncertainty for the VA and other federal agencies. But in the long term, the Fifth Circuit's logic, taken to its natural logical end here, could impede the work of the Veterans Administration. And my clients felt it was quite important for the court to understand and carefully consider the collateral damage that any ruling here could have for veterans, even beyond the CFPB. So that's all I have for now.
Good afternoon. My name is Armin Meyer. You've made it. I'm the last speaker before Q&A, so consider me please your warning that you have a few minutes left to place any questions into the chat. More importantly, perhaps, I'm the co-founder of the American FinTech Council and chairman of the board's Public Policy Committee at the American FinTech Council. The American FinTech Council, AFC, includes nearly 100 for-profit companies that invest in technology to deliver better financial services. We range from low-cost loan providers to online neobanks to automated compliance services firms. We wrote an op-ed on today's topic over the summer, and I'm going to expand on that op-ed here today. But first, let's just be very clear about what is happening here. This effort by old-style lenders, some of whom were just mentioned by JP, to destroy CFPB regulations is serious. But it's not serious business. It's anti-business. If successful, it will derail investment and innovation. It will harm the economy, and it will advantage companies who are not serious about creating products that are good for consumers. You don't have to agree with every single CFPB regulation to understand that the regulations have improved regulatory certainty, which has empowered economic creation in this country. Case on point, the very payday lending rule under challenge in this Supreme Court case. The regulation defines nationwide for the first time what payday loans are and what high-cost loans are. As a result, an entire industry of fintech lenders was born with more clarity to know how to structure a product that is not payday, that is not high cost, thereby reducing regulatory risk across federal and state agencies for these new entrants. As the first federal law drawing this line for all consumers, not just the military, all consumers, dozens of new companies have been able to lower the cost of credit for Americans. Borrowers have saved billions of dollars, billions B, and have obtained responsible credit to invest in their future, where they might have instead received some tricky product that harmed their future. But the stakes of this case go way, way beyond this particular CFPB regulation, as others have alluded to. Any legal logic that strikes down this payday regulation would scarily essentially imply striking down all CFPB-issued regulations. Three main points here. There are many, but let's focus on three. One, the mortgage markets would be just decimated if CFPB mortgage regulations were struck down, perhaps as bad as what we saw in the global financial crisis 15 years ago that Amais alluded to. No responsible mortgage lender in AFC or otherwise wants a return to the lawless days when predatory products infected the economy and affected the American homeowner who became underwater on loans they did not understand. Rather, responsible lenders want the regulatory stability that recent CFPB regulations have provided, from guiding proper product structure to requiring licensing of mortgage originators. But beyond mortgages, secondly, going to the entire lending markets, without CFPB issuances, we'd go back several years in time to not knowing if artificial intelligence algorithms, for example, are covered by laws that prevent discrimination in lending. AI and machine learning algorithms are clearly covered today due to CFPB guidance at members of industry's request. So industry now has more regulatory clarity to invest in these algorithms to provide more affordable financial products, which we don't really want to lose. Third, and worst of all, now let's go way back in time. Let's remember that Dodd-Frank caused the CFPB to reissue many consumer regulations. Many of these go back to the 1970s. So these rules are now in some jeopardy too. These rules include the nation's first data privacy protections and even regulations governing fee transparency in personal savings accounts. We're now in the 21st century. Drones are fighting wars. Private companies are sending private citizens to outer space. But the Supreme Court is being asked to send us back to a regulatory environment that existed before personal computers and ATMs. The reality is that for capitalism to work, there just have to be common rules that we all adhere to. At a bare minimum, we need rules that empower customers to make informed choices so markets can work and then the best products can win. The winners of a world with no rules are companies that create fraudulent products, predatory products that take advantage of seniors or the financially vulnerable. Those companies can declare bankruptcy, can change their names when their schemes are discovered after short-term profits are made. But companies that want to build technologies that actually help people in the long run are going to end up going down with the very regulations that are in question here. So let's pray that the Supreme Court does not throw this all away. Thank you.
All right, we want to thank all of our speakers for their expertise on this topic. And we're going to pivot to questions. So the first question is for Brianne. This is an originalist court. What is the originalist argument for keeping the CFPB funding structure the way that it is now?
Sure. I mean, I think the originalist argument is an incredibly strong one in this case. It's the argument that I laid out very briefly before, but that's discussed in much greater length in the amicus brief that my organization filed on behalf of Aziz and other scholars of history and constitutional law. The short of it, again, is that the text of the Constitution is very simple. It's very straightforward, and it imposes none of the limitations or requirements or restrictions that the Fifth Circuit sought to impose. The history only underscores that text. The history makes clear that the Appropriations Clause was designed to give Congress discretion over how the nation's agencies and federal programs were funded. It was designed to serve as a check on the executive and not, as the Fifth Circuit would have it, as a judicial check on the legislative. And so a Supreme Court decision affirming the Fifth Circuit, holding the CFPB's funding structure is unconstitutional, would fly in the face of the text and history of the Constitution. The Fifth Circuit in its decision engaged in a lot of rhetoric about the separation of powers, but it really didn't engage with either the text of the Appropriations Clause or its history. And it's really, really difficult to conceive of how the Supreme Court could write an originalist opinion holding the CFPB's funding structure as unconstitutional.
Thank you, Brianne. Anyone else want to respond to that before I move to the next question? All right. This question is for Aziz. Is the structure of the National Credit Union Administration protected even if the payday lenders win with the Supreme Court? To what extent would NCUA be protected by double insulation or the double insulation doctrine?
It's difficult to see why the NCUA would withstand a constitutional challenge if the CFPB's funding structure was three reasons. The first reason is the reason that I offered, which is there's no principle on the distinction falls away. Second, as Amias explained, the CFPB does not have double insulation. In fact, so if the CFPB is struck down, then all single insulated agencies would be amenable to constitutional challenge on the basis that, in fact, the CFPB has no double articulation. The third, assuming that there is a distinction between single and double, is there is an intermediating structure, which is a trust fund that's administered by the agency, from which the agency draws its funds. That can be characterized as a double articulation, much as the Fifth Circuit tried to characterize the CFPB structure as double insulated. So I don't see any reason for optimism about the National Credit Union Agency if the CFPB loses this case.
Thanks so much, Aziz. This next question is for Amias. Behind the housing market is the whole mortgage-backed securities market, the QM rule, and the like. All rules that the CFPB wrote to keep the securities market functioning. What does this case mean for the stability of that market?
Yeah, so as Armin said, this is a really important point, and I think it can be sometimes a little bit misunderstood. So the fundamental stability of these markets is not just that there is an agency that can write rules, but rather that there is an agency that specifies what those rules mean. And it is in the specification of those meanings that market actors draw their legal certainty. So, for example, using the QM rule, a qualified mortgage is the idea that there are certain mortgages which are exempt from legal liability on ability to repay. So there are certain legal standards. However, the definition of what a qualified mortgage is, so there's basically like, hey, here's, if you do this without this exemption, then, you know, something bad happens, you can be sued. Something bad happens, you know, the consumer can come after you. Under the QM, you have a different legal standard. And so this creates two very different markets. In order for a mortgage lender or a buyer of a mortgage-backed security to know what their legal risk is and know what their pricing is, they need to know which environment they're in. And without a rule that sets the dividing line, you simply cannot enter into that market. So not only would it invalidate, if any of these rules were unstructured, it immediately invalidates the question of, you know, I made this loan on the theory that it was a qualified mortgage. Now, the qualified mortgage is a creature of law, but the definition is a creature of rule. And so if you make a loan thinking it's a qualified mortgage, and then the rule is struck down, well, who's to say whether it's a qualified mortgage tomorrow? And if it's not a qualified mortgage tomorrow, then who could buy it? If no one can buy it, then how could we make a new loan? And I think that is precisely the dynamic that Armin explained when he said, you know, private companies, they need legal certainty in order to enter into these markets. It's not that the legal certainty gives them this protection or that protection. It gives them certainty as to what protections they do have, what protections they don't have. And that certainty is what allows them to price, and it is the ability to price that allows them to make loans. And it is simply as simple as that. If you cannot price a loan, you cannot make a loan. And that is the way every financial services company in the country operates, whether they're in primary markets or in secondary markets.
The next question is for Armin. Why would industry be in favor of CFPB regulation? Do you like this regulator? It's very odd to hear that from industry.
Well, so I'll pick up. So Amias picked up some of my comments, and let me pick up on some of his, because in addition to what Amias just laid out, which I won't try to redo, there's other reasons as well. One, once you have rules of the road, you have to invest in them if you want to be a successful company that can create great products. And if you're a tech company trying to lower the cost of credit or trying to reach people who haven't traditionally been reached with good products, that's a lot of dollars being invested. So, and you use the rules that exist when you create those products and when you invest in technology. So if those rules suddenly disappear and change, A, your investment has now perhaps been squandered. And then B, you have to redo a whole lot of things. And then others can come in and do things in a way that maybe wasn't as responsible, or maybe wasn't as serious about investing in the tech in the first place in order to comply. So that would be another reason on top of the minuses. And I'll throw a third one in too. A world without rules is a world where enforcement is the only thing industry has to look forward to. We rather know what the rules are so that we can, again, develop those products around them and limit the risk that we do the wrong thing than have a ruleless world where enforcement reigns, whether it's the CFPB or any other agency in the country. So we need clarity to succeed. And those are 3 reasons right there why we like rules.
That is golden. The next question is for JP. The Chamber of Commerce has said that the Supreme Court confirmed the rules the CFPB has created, but in its funding mechanism until Congress acts. Wouldn't that be a good way out?
Interesting question. My short answer is no. I think that would be sort of like having traffic laws but no traffic cops. It might work in theory. I don't actually think it would even work in theory, but I'm driving into New York City tonight. I don't think that would. My experience driving in Manhattan is that wouldn't work terribly well to just have these sort of nebulous traffic regulations hanging out there. That maybe in an ideal world everyone would just obey without enforcement, but that's not how our system of law tends to work, right? We have different teams of civil and criminal enforcers and regulators to apply and enforce the law. So I just don't think that's a real world argument. I mean, in the real world that my clients live in and work in, these are veterans and service members that engage with complex financial products, face complex problems, and sophisticated and sometimes shifting sort of predatory actors. And so the idea that you could just have these regs out there without like any staff, anyone actually getting paid to look at the law, is just not realistic. And the enforcement record that we lay out in our brief in some detail, I think, reflects the complexity and the importance of having an agency, a bureau here with substantive expertise and staff and funding to actually enforce the regulations they promulgate. So no, not practical.
Thank you. All right, next question for Elise. We keep hearing that this is a case by payday lenders. What regulation do they hate? What do they want? And why is that a bad thing?
Wow, for me. Okay. So payday lenders historically have preyed on those who are low income, BIPOC communities. They charge upwards of 300% for those loans. So the CFPB comes in to basically say you're not allowed to prey on the most vulnerable of the socioeconomic system. So they didn't like the payday rule. They don't like the regulations that come into play to pad their bottom line. And what they want is for the CFPB not to exist at all. And that's a bad thing because circular, just as I said, the lower socioeconomic system or the people with bad credit or low income or BIPOC communities, you're digging them into a deeper hole. You're not allowing them to save money or climb the socioeconomic ladder when you keep preying on them at very high interest rates. So in a nutshell, that's just my opinion as to why the payday lenders do not want the CFPB to continue to exist. So 6th question is for Brianne. Bottom line, if the Supreme Court upholds the Fifth Circuit's decision, will it cease to exist? Will the CFPB cease to exist?
Well, I mean, it seems like if the Supreme Court upholds the Fifth Circuit's decision, the natural consequence would be that the CFPB may exist as an agency, but it would be without any funding to do the incredibly important work that it has been doing since its creation. That would be, for all of the reasons that folks on this call have discussed, just a catastrophic result with, serious significant implications for our financial markets, our housing markets. And if the Supreme Court were to uphold the Fifth Circuit's decision, the consequences, of course, could be much more significant than that, even as significant as that would be, because it would call into question the constitutionality of the funding of lots of other federal agencies, including the Federal Reserve, and lots of other federal programs. So, I think thinking through the real implications of a decision upholding the Fifth Circuit's decision, underscores why the claims by some on, the support side of the payday lenders that this could be a moderate or mild ruling that would not have significant implications, it just strains credulity.
Thank you, Brianne. Are there any questions that are remaining among the audience? All right, no more questions. Well, I'd like to thank our partners, AFR and CAC, on behalf of CRL, and also the group for a group of panelists and the folks who are attending. Elise?
Yes, I'd like to echo Nadine's sentiments. Thank you all for attending. I want to thank our experts for their expertise on these subject matters and answering questions. And with that, thank you all for attending, and thank you all for being here, and we will see you next time.